panel today. We have quite a bit to talk about. We're going to be discussing the perils of litigating separation of powers issues. Everything from DACA to the Emoluments Clause to the travel ban case and presidential motivation with respect to those issues. So I'm going to be very quick. We're going to introduce the panelists. They're each going to give 10-minute statements, and then we're going to have some moderated discussion, and then open it up for questions from the panel. So, questions from the audience, not from the panel. First up is Bob Bauer. He's a professor and a distinguished scholar in residence here at NYU. He was also President Obama's White House counsel, my old job. Without further ado.
Well, thank you very much. I really appreciate it. I'm very glad to be here, particularly on this panel and with these panelists. Let me, first of all, address sort of the context in which I'm making these remarks with reference to my own background. I can imagine the immediate thought, since I was in the Obama administration, was that I have a different view of presidential power today than I did just a few years ago. A few years ago, I might have looked on it very charitably, and today, oddly enough, I may not. I don't think that's right. You have to take my word for it. I don't plan to write a memoir for all sorts of reasons, but I have had for a long time, and I think these issues are difficult, considerable concerns that I think are shared on both the left and the right about the growth in the power and the manner in which the power is exercised in the presidency. And so I begin with the fundamental proposition that as we approach this question of how we look at presidential intent, the use we make of presidential rhetoric in challenges to exercises of presidential authority, I think you have to begin by situating your thinking about this within at least some conception of where the presidency as an institution stands today. And I mentioned just a second ago that the concerns here are across the spectrum. I mean, whether you begin long ago with the famous imperial presidency, the term I think coined, or at least made famous by Arthur Schlesinger Jr. in the book by that name, but then you go to contemporary critics from Peter Shane at Ohio State to Frank Buckley at George Mason. There is an uneasiness about the presidency as it currently stands, the expectations of the occupant, the powers that have devolved on the institution, the way in which in recent administrations, and you can pick your point of departure if you like, the trend toward outsized authority in that office have accelerated. And keep me posted on where I am. I think I may have forgotten what the starting point is.
We have 7 minutes.
That's that. I'll whip right through here in 7 minutes. So I think we begin with that, and I'll register myself as somebody who has that concern, and it's with that view that I want to say something about 2 issues that have come up recently: the use of campaign rhetoric in adjudicating a case like the travel ban, and then other inquiries into presidential motive, which, by the way, rhetoric can also figure in some of the claims that have been made about potential obstruction of justice or misuses of the pardon power. So let me just very quickly say that if we do believe, as Jeffrey Toulis wrote in a well-known book, we do believe that rhetoric is a powerful tool of the presidency. We expect the presidents to use rhetoric to strong effect. We tend to value the presidents who are the powerful rhetoricians or the effective rhetoricians over the ones who are the weaker versions. Then it seems to me we've already conceded that words matter, and they matter in the case of the executive. And there are 2 additional points to be made about the importance of words. One of them is that as the office becomes more powerful and in many respects more opaque, what the president actually has to say about what he means, and I'll get to the campaign side of this in a minute, has to become that much more significant for us. The campaign, for its part, is an element of the way in which an individual who seeks the office of the presidency begins to establish an understanding about what kind of a government he or she plans to establish. Campaigns are not simply about words, they're also about commitments. And so if we talk about the rhetorical presidency, then I think we also have to live with the significance of words, not only in judging a president in sort of the loosest possible sense as sort of a leader, an inspirational leader, but also the words as part of the record that we have to repair to in thinking about what the president has done, what he meant, and what subsequent actions might have been shaped by. In the case of the travel ban, I know that there was an enormous amount of anxiety in the famous dissent by Judge Kaczynski about what it means to go back and look at what candidates say on the campaign trail. However, I thought that concern was highly overwrought. Obviously, there are distinctions that have to be drawn between campaign bluster and commitments that presidents make and express in strong terms as a central plank in their proposed governing program. And this was a central plank, repeatedly returned to by the president in his proposed governing program. And they were consistent with post-campaign statements that he made, and they occurred not too long before the first travel ban executive order was issued. We can talk later, I don't have time for it, about why I think the court correctly looked at this complex issue and came out the way that it did in attributing some significant weight to what the president said. And then very quickly on the question of looking at presidential motive in matters like the exercise of, in most instances, uncontested presidential authority, for example, to fire a subordinate official like the FBI director, or for that matter, to issue pardons. I think it is very important, again, for all the reasons I described just a few minutes ago, that we look at the claims that are being made in the context of the way the institution has developed to this date. And if we take the position that we're going to carve out large spaces within which the president can, if you will, evade inquiry into motive, then we're taking a step still further down a road that I think many have found very troubling, and which I, even as a Democrat over the years, a party known to be rather taken with the potential productive uses of government, even I certainly have found troubling. Last point I would make, and I'll close on this, there are hard cases, and very frequently what I'm saying is challenged on the ground that it involves the courts in particular, sometimes the Congress in the exercise of its oversight function, in highly intrusive examination of presidential conduct, inevitably politicized, and beyond the capacities of the decision maker. And there are indeed hard cases, but there are always hard cases in areas that we care the most about. And for that reason, again, citing the travel ban as an example, when the case is a very, very strong one, we don't shy away with it because we know there are harder ones that we still have to confront down the road. So I think I'll stop there.
Thank you so much, Bob. You're very fortunate to have his perspective. I will make the same disclosure that Michael McConnell made earlier. I didn't vote for Donald Trump. In fact, I signed a fairly prominent letter called Originalist against Trump that laid out many of my concerns with him. That has not inured to my benefit, but it's okay. I'm still here. Yet in the last year and few months, I found myself in this strange position as one of President Trump's few defenders in the academy. It's not a role I relish because I frankly disagree with but many of his policies in immigration and otherwise. The judiciary is killing it, but in other areas, not so much. Yet, I still have this concern that if we start injecting the federal courts into all manner of presidential action, it begins to disable the president from acting as the president. And Bob and I have gone back and forth on the Lawfare blog a few times concerning obstruction of justice. And obstruction of justice is the new thing. Everything Trump does, doesn't do, even considers, is now obstruction. Even the consideration of giving a pardon might be obstruction. I think we have these wild, untested theories of liability that are serving to delegitimize the presidency. And I think there's a distinct risk here. I'll focus my remarks at the beginning on what I call presidential free speech, and Bob alluded to it a moment ago. When the president speaks for the nation, he speaks with one voice as the sole organ of the U.S. government. This off-sided dictum from U.S. versus Curtis Wright was actually originally voiced by John Marshall back in 1800. But generally it's not taken literally. In most cases, courts listen to the sole organ speak through the form of policy statements issued by the executive branch or even by briefs from the Justice Department during the course of litigation. Seldom do we have statements from the commander-in-chief himself. No longer. In less than a year, it has become de rigueur for courts to cite President Trump's tweets and other statements in judicial opinions. Indeed, when there's a conflict between the Justice Department's litigation position and the president's social media, the courts have deferred to Twitter, as it were. In doing so, these courts have relied on an unstated assumption that the president is telling the truth. This assumption is often factually inaccurate. The president, like all politicians, lies. They lie for different reasons, right? I did not have sex, right? They lie for different reasons or for no reason at all. So in a new article I'm writing called Presidential Free Speech, I assess the constitutional limits of this emerging jurisprudence based on presidential speech. So 3 major points I want to discuss. First, the Constitution protects lies, right? United States versus Alvarez recognized that false statements, quote, do not constate a new category of unprotected speech. Courts cannot and should not assume that everything the president says is the truth. I think we all know that's an empirical matter. Perhaps the president misspoke. Perhaps he knowingly stated a flat-out lie. Perhaps he no longer stands by a lie he told in the past, but hasn't repeated it for political reasons, right? So long as the statements were not libelous, or perhaps incited violence, or constituted fraud, these untruths are protected by the First Amendment and cannot give rise to civil or criminal liability. Yet courts have unflinchingly relied on these statements, which were not submitted under oath, as if they were gospel. Okay? The second point that I want to discuss is that the Supreme Court has recognized the centrality of a politician's responsiveness to the political process. Again, the president isn't merely some sort of idealized figure. He's not George Washington. He's a politician, and he got through politics. For example, McDonald versus United States, this case involved the former governor of Virginia, who had a little problem for his own. The court recognized the importance of allowing, quote, conscientious public officials to, quote, respond to even the most commonplace requests for assistance from constituents without fearing a federal bribery prosecution. It was a 9-0 case to reverse the conviction. Otherwise, the court said, citizens with legitimate concerns might shrink from participating in a democratic discourse. This democratic discourse seldom concerns Mr. Smith goes to Washington version of idealized governance. More often than not, it is grounded in the rough and tumble world of partisan politics, especially in the context of political speech. Now, perhaps the president made a promise he had no intent to keep in order to help win the nomination. This is so-called appealing to the base strategy. Well, let me tell you something. That's how you win elections, appealing to the base. That is not a criminal act. Maybe people would want to become one. Or perhaps the president made an inflammatory remark to pander to his political base. Maybe he meant it, maybe he didn't. Again, these remarks are at the core of political speech protected by the First Amendment, and courts should recognize this fact when citing tweets, and they sure as hell should recognize if there's ever a federal obstruction prosecution based on these sorts of statements. Third, when courts rely on the president's statements without countenancing the possible political motivations behind them, they threaten to chill an important and long-standing aspect of our polity, the bully pulpit. Justice Kennedy observed in Alvarez that a broad censorial power that punishes untruths could cast a chill the First Amendment cannot permit if free speech, thought, and discourse are to remain the foundation of our freedom. Courts have cited political statements, even those made on the campaign trail, without recognizing the chilling effect this has on a central aspect of our republic. This approach also punishes presidents who change their minds, perhaps in the advice of his cabinet after assuming office, but they don't change it publicly. There was this big fuss made about statements in the president's website that were not taken down. Donald Trump's not a webmaster, right? Can we ask the president what he thinks? Maybe yes, maybe no. But courts have relied on this as dispositive evidence that he maintains exactly what was on his website for a year. I think there's some problems with this. Now, it is yet to be known whether politicians in the future may choose to stay silent so as to prevent courts from using their own words against them. Perhaps this risk of chilling may be justified, but it should be acknowledged. And to the extent possible, the rough and tumble world of politics, the president should stay out of the board. Max, how much time do I have left?
3 minutes.
3 minutes. Let me address a broader point that was raised in the prior panel about whether courts have perhaps developed a separate set of rules for President Trump. And this is a theme that I've developed at some point. Someone taken out of context, but I'll try to give it justice here, no pun intended. In the early days of the Trump administration, we saw a series of rulings that were frankly stunning. You had judges issuing global temporary restraining orders against an exercise of the president's executive and statutory authority on only a few hours' notice. You saw people relying on untested theories of jurisprudence, looking at presidential animus in ways that had never been studied before. And this was done, I think, in a somewhat understandable reaction to President Trump's unprecedented form of governance. We never quite had someone like this before. I was very critical of these sorts of rulings, especially when it concerned the president's constitutional authority. I was a little bit more sanguine when it involved statutory cases like the trans ban and these other things. But the travel ban in particular, I think, is a very unique example. One thing that I'm actually pleased about is the Supreme Court has been a moderating influence, right? Despite the various global injunctions issued on the travel ban by the lower courts, the Supreme Court intervened last December and allowed the travel ban to go into effect in its entirety. So now we are 3 or 4 months later, the policy is in effect and the world still moves, the world still turns. I think the president will prevail on the travel ban. I don't know the exact theory, but I do think the president will prevail. But I do hope this sends a signal to the lower courts that perhaps they were not doing it quite right now. Lower court judges are independent. They're not required to listen to the Supreme Court. They often don't, pretend to, they don't always do it. But I'm glad that there's this equilibration where the courts are starting to settle down and react to Trump in a manner in which they would react to past presidents in much the same light. But I still think we need to study this first year of the Trump presidency, not only in terms of executive branch excesses, and boy, there were plenty of those, but also judicial branch excesses. And if, as Michael perhaps predicted before, the House flips in 2018, I think we'll have some legislative excesses to talk about as well. Thank you all so much.
I want to thank the students of the Federalist Society for putting together this program. Appreciate your efforts. There are 2 things I'd like to, first of all, on a disclosure, I also didn't vote. I wonder who did.
I didn't.
I also didn't. I regard myself as a democratic liberal, although maybe many liberals don't regard me that way. On national security issues, I tend to be more conservative. And I'm on judicial, what I call judicial activism. I'm an old progressive. I'm very critical of judges getting into politics. So that shapes my perspective on the 2 things I want to talk about. One is the Nationwide Injunction, and the other is what I call impeachment of presidential authority for bad motive. On the Nationwide Injunction, I fear there is no good legal rule that restricts the Nationwide Injunction, but we need one. The problem with the Nationwide Injunction is, as a practical matter, people can pick their district judges. I don't believe this reflects a sea change in judicial attitudes. This is plaintiffs. This happens across administrations. It's not just a Democratic liberal gambit, it's also a Republican conservative gambit, as it was during the Obama administration. You pick a district judge, and for a district court to be able to sort of make policy for the nation strikes me as problematic. And to also force the Supreme Court's agenda. I did a paper with Ricky Rivez many years back on administrative agency non-acquiescence, and one of our principal points was that the Supreme Court had rejected non-mutual collateral estoppel against the government so as to avoid this kind of nationalization of the opinion of a single district judge, so that the Supreme Court benefits from percolation among the courts, not because the lower court judges are brilliant, but you want to have some experience with different approaches and different formulations. The Nationwide Injunction presses the issue to the very top of the agenda of the Supreme Court. It's inconsistent, at least in spirit, with the United States versus Mendoza ruling on non-mutual collateral estoppel. I think in the interest of good government, we ought to figure out some constraint on it. Now, Circuit Judge on the 5th Circuit proposed some analogy to 3-judge courts. My approach would be that the district court's authority is limited geographically by the boundaries of the circuit. And that would permit the executive, the president, to continue to litigate that issue without fear of contempt in other circuits. And if in fact is able to prevail in some other circuits, that's a good signal to the Supreme Court that's a case they should take. I'd like to think this is a good government position. It's neither a Democrat nor Republican, neither conservative nor a liberal position. You've got to move away from this nationwide injunction. It's a new form of government by injunction. And ironically, back in the 20s and 30s, there had been a different form of government by injunction. So the second issue I want to look at is impeachment for bad motive. Now, President Trump has provided a very rich target in this area. And unlike Josh Blackman, and a little bit more in keeping with what Bob Bauer has said, I'm very troubled by the president's unfiltered remarks, because part of leadership is what the president says. It's highly problematic. I don't know if it's constitutionally problematic. I'm not saying it's criminally problematic, but this is an important part of the authority of the president. It's being squandered in ways that is really not helping President Trump at all. He happens to be a not very good articulator of public-sounding, public-regarding justifications for what he does. I'm hoping the national security area, Bolton will step in and give the rationale for national security moves. And maybe in domestic policy he could use another spokesman in that regard, because he is a very, very bad articulator of what in fact is the reason for what he is doing. Now, because of this target-rich environment of President Trump, things he said in his election campaign, I'm sure they count to some extent. I doubt that he articulated a central plank of his administration, other than saying he wanted to deal with the immigration problem. That's part of his mandate, to deal with the immigration problem. And there's a good government reason to care about that. If you want to normalize, legitimate the presence in the United States of undocumented aliens, you have to do something about the border. You have to do something about visa control. All that has to be done. So I'm worried about this reliance on motive, impeachment for motive. Why? Administrations change. This may be a president you don't like, a president you don't respect, but their administrations change, and these techniques will have their own sort of precedential weight over time. These techniques of challenge. Secondly, about motive inquiry. It's highly problematic. It's problematic in almost every area of law that we see. One, it's an extremely time-consuming inquiry, number one. And when backed by a nationwide injunction, it effectively places the administration under the threat of contempt, and it will take many, many, maybe years, certainly many months, to untangle the motive inquiry. Secondly, is the problem of dual motivation. Now, maybe President Trump, in an unguarded moment, looked at his own private litigation and said some unfortunate things about a district judge. But he also has this other concern, which he clearly has presented, with the presence of undocumented aliens in this country and doing something about it. There's always a problem with dual motive. It is said that President Truman really wasn't interested in the war effort in the steel seizure, but really was providing a favor for his friends at the United Steelworkers. The Benghazi incident, there was a dual motive there. Partly there's a political motive. Now, most presidents are guarded. They don't put this out in their social media, but there are dual motives. And by the way, just because they don't put it out in social media doesn't mean it can't be an inquiry in a judicial action if you have a district judge that wants to make it an inquiry, because there'll be some residue of that motivation. Dual motive is a serious problem. Related problem, multiple layers of actors. And, you know, the executive order and the travel, I call it the travel pause case. It's not a travel ban case. But the actors in the travel pause case, there are multiple layers of review. Now, maybe you folks believe that Trump is such a persuasive guy that he dominated all of those proceedings. I find it hard to believe. His administration came up with a rationale. On the face of it, seems to have some persuasiveness. Maybe it doesn't have ultimate persuasiveness. Maybe you should strike it down because it's not a reasonable rule under the arbitrary and capricious standards of the Administrative Procedure Act. It's not clearly, to me, an establishment of religion. I was sort of flabbergasted when I heard that theory. Turns out Josh has some originalist,
usually do.
some originalist understanding behind it. It really is, I think, quite a remarkable claim that that is an establishment of religion. So motive inquiry is time-consuming and it's highly elusive. And interestingly enough, it runs counter to what Elena Kagan, when she was only a mere professor, advocated of an energetic president. The very words that Wilson used, the energetic president. Where the president doesn't delegate across the board, so it's multiple layers, but has a kind of imprint on the policy. If you open motive inquiry, you provide an important check on that energetic president. So, 1, administration's change. 2, motive inquiry is inherently problematic. 3, as I said, the federal judges unfortunately have become polarized. And I think it's only going to get worse because we now have the nuclear option, which was an enormous mistake. So the centrist judges, as McConnell, for example, was a centrist judge. I supported his nomination publicly. But unfortunately, he left the bench, creating a vacancy. But I think, in fact, we're going to have more ideologically colored judges, to the detriment of this country. Plaintiffs pick district judges. Anyway, so those are general concerns I have with motive inquiry. So I began thinking, where have we recognized motive inquiry? And it happens to be an area that I live regularly in, employment law. And let me give you some features of motive inquiry in employment law. 1, it tends to be statutorily authorized. So to some extent, Congress has brought this about. Secondly, motive is the issue. There aren't other ways of challenging the employment decision for regularity of process, generally under federal law, arbitrary capricious review. Motive is the triggering event for regulation. Third, we're usually dealing with a single decision maker. It's one supervisor. Usually, there are some multi-decision maker cases which are very, very hard to handle. It's usually one decision maker, that supervisor, that decision maker. Fourth, limited impact. If you find unlawful motive, you impose damages on the employer, or maybe the employer will fire that decision maker. There's a limited impact. 5, under the substantive law, including the substantive law that applies in constitutional 1983 claims, there is what's called a same decision complete defense. That the employer has the burden of persuasion to prove that it would have reached the same decision in any event, and that's a complete defense to liability. Now, Congress changed that rule with respect to Title VII, but that's the constitutional rule. Complete defense to liability. Can we do that here on this plane? And then finally, there's an opportunity to restore the situation. You fire the decision maker, you can now continue making employment decisions. What do we do with motive inquiry if, in fact, we find an unlawful motive? Does that mean the country is disabled from the visa control program that President Trump and his administration, and that strikes me as an unbelievable outcome. Now, in the religion context, this is an open issue, it hasn't been worked out. I think the impact in the religion context is quite limited. Usually it's some sort of aesthetic concern. Do we want the 10 Commandments, which I'm a big fan of, standing alone, or does it have to be part of a multi-religious display? That's the issue there. Do we want a moment of silence? Now, again, there is an impact to this litigation because is it unconstitutional because of the religious motivation of the legislature? There's an impact, but it's a limited impact on the polity, I'd argue. And it's not clear to me why there is not a restorative opportunity. I think this has not been fully litigated. Just because you find that some legislators at time one had a religious motivation in a moment of silence, does that mean the school boards are disabled for all time from having a moment of silence? How do they cure that impact? There's got to be a curative impact, and it's recognized in employment law. So let's take the travel ban. I'm not sure there is a statutory authorization for the motive inquiry in the statute. Now, there's an issue about one of the provisions, and Josh maybe could talk about it, dealing with national origin. This is going to be worked out by the Supreme Court. Petitioner said it had no applicability with respect to folks. That'll be an issue there. We have multiple levels of decision maker here, very serious problem, and we have a serious impact. We're going to second guess the government's view. This is really quite extraordinary. We're going to second guess the government's view, if we take seriously the outcome of a motive inquiry, second guess the government's view that this sort of visa control is necessary for the national security and because of the information gathering limitations of some of these countries. So what's my takeaway? My takeaway is stay away from this motive. Stay away from the allure of impeachment by motive. Go through the other means. So for example, now there's an issue about the question on citizenship on the U.S. Census application. Now, that question has appeared in the long form, as I understand it, but the innovation here is now going to be in the short form. There is a fear that it's going to discourage people from answering the inquiry. All very legitimate concerns. Well, address them. Address them through arbitrary capricious review. What raises my hackles is the MSNBC, I hate to say this, CNN crowd, jumping immediately to the fact that Trump is a racist, and that's the end of the analysis. Now, that's just really debilitating for our polity.
So I have a question for Professor Bauer about what a motive-based inquiry would look like. So you had mentioned in the travel ban case in particular that this was a central plank of the campaign, and that this was something that he really made an issue about, said these things numbers of times. Maybe using Professor Stryker's typology, what would a motives-based inquiry look like, an appropriate one?
Well, first of all, I want to speak to that issue without saying that in every respect, and let's keep in mind these decisions were made under pressure, so courts don't always show especially well when they're producing outcomes under pressure, that I'm embracing each and every aspect of how the courts have engaged with Donald Trump since the beginning, or even necessarily in that litigation. I thought that the original Ninth Circuit and Hawaii decisions were defensible for a variety of reasons, but I just want to be clear. I'm trying to take a sort of balanced approach to this. And the question that I want to sort of stress here is it seems to me this conversation has raised or has sort of traveled in three different directions overall. One is there's been discussion here about essentially judicial overreach, period. Courts, Professor Stryker is talking about the Nationwide Injunction and the issues with that process. The question of sort of judicial overreach and failure to be sensitive to the boundaries of the role. And then there's the question of whether in engaging in this sort of systematic usurpation, they are being impelled particularly to act unwisely in responding to Donald Trump. You can have that conversation. Where I would like to go, in part, in my comment, is whether you're talking about Donald Trump, you're talking about another president, how should the courts appropriately respond? And are they, just as a presumptive matter, which is how I take Professor Blackman to be arguing his case, are they to be asked not to have the doctrine rule out the consideration of statements that presidents make on the campaign trail of whatever kind, however unbounded, however repetitive. And I understood Professor Blackman to say, well, politicians will be politicians. I don't think presidents are entitled to shield themselves on that claim. I do think there's a question of execution. Obviously, we expect the courts to go about judiciously looking at the cases where this inquiry into the motive based on speech is appropriate, and other cases where it may not be appropriate. If you ask me whether I have a formula to assure that they hew correctly to the line, no, the answer is I don't have a formula, and I suspect we're going to see this worked out painfully, as is so often the case in a complex jurisprudence, case by case. Just one last example, if I could just slightly shift from travel to Professor Blackman's comments about obstruction. He said almost anything Donald Trump does is being treated as potential evidence of obstruction. I don't really see that in the public commentary, although I suppose if I were sort of Twitter-minded, I could find plenty of evidence for it, but I don't scurry around on Twitter looking for the extreme views typically. But I do believe that it is appropriate to take seriously when the President of the United States, in a case that involves potentially his liability, that of family members and associates, publicly says, I fired the person who leads an investigation because I didn't like that investigation and I want to shut it down. If he says that publicly, where we take that, what weight we assign it, to what extent it moves an investigation forward, those are all legitimate questions, but I find it very difficult to understand how the president's expressed motive for taking actions of a self-protective nature in the presidency of today is not something that we should be concerned about.
So, Professor Blackman, you've said before that you don't think that the president can commit obstruction of justice when it's in
This is why he's a good moderator.
When it's in the discharge of his Article 2 duties, would you care to elaborate on, even in an egregious, I mean, I guess the most egregious situation that you could come up with, do you think that that's when he's potentially protecting him or his family from corruption in a personal capacity? Do you think that that still holds true?
Sure. The president is not above the law, but he is special. We know that the president cannot be sued for actions that arise in his official capacity. I don't think the president can be subject to a criminal trial while he's in office. I think the president may even pardon himself. We can debate that perhaps later. In a trial 200 years ago with Aaron Burr, Chief Justice Marshall wrote, "In no case of this kind would a court be required to proceed against the president as an ordinary individual." John Marshall. John Marshall, pretty big guy. I don't like him very much, but I think he was right there. Right? The Constitution gives two people in this United States powers: the president and the vice president. No one else. It gives bodies power, but not individuals power. And I take these powers given to the president and the vice president as significant. And these put limitations on statutes Congress can pass. I'll give you a very easy example. Let's say Congress passes a statute that says the president must recognize the new Republic of Zamunda, right? We forget the reference, right? And the president says, "I'm not recognizing Zamunda, I'm going to ignore the statute," and they override the veto. Would the president be impeached for violating that statute? I think the answer is no, right? This recognition power, this power as chief ambassador, is given to him by Article 2. Congress cannot criminalize that act. They cannot make that a crime. I don't think Congress could impeach him for it. So this is why I almost jumped on poor old Max. Some people have said, like Dershowitz, that he can't be prosecuted for obstruction, period. I don't think that's right. But this is a lawful exercise of the president's power. I don't think he can be impeached for it. I think the pardon power is pretty damn near absolute. So now, let's talk about speech. We have First Amendment rights, and so does the president. I think it would be a travesty for Congress to make a law, an impeachment resolution, that violates the president's free speech rights. There's a speech or debate clause for sure, but there's a First Amendment also. So they're both negative and positive limits on Congress's power to prosecute obstruction of justice, and I think impeachment. People don't remember this, but one of the articles against Andrew Johnson back in the 1860s was that he was disrespectful to Congress, that he harangued Congress during some joint session, right? Could President Trump be impeached for going on a rant at the State of the Union? I don't think so. I think he actually has a duty to give the State of the Union. That's in the Constitution as well. It's also a positive right. So look, we have this thing. Could Trump pardon, was it Flynn or whoever else, and Ivanka and Jared and Tyler and Shpoka, right? Could he do that? Yes. Would he win re-election? I think the answer is almost certainly not. In other words, we're going to have an election sooner than you know it, right? By the time this thing winds its course, we're right at the eve of an election. Throw the bum out of office, right? If you don't like him. I think Michael made a very powerful point before. Having these criminal prosecutions and these impeachment trials for these sorts of matters, which is not a good bipartisan consensus like Nixon, is not healthy. I'll leave one more thing. Preet's not here today. Preet Bharara was perhaps wanting off against this panel. Could the New York Attorney General indict President Trump in state court? That's my question. Could the Manhattan DA, Cy Vance, prosecute the president in state court and indict him? We just had a New York State Supreme Court justice rule he can be liable for civil suit in court. I think that's right with Clinton v. Jones. But could the president be indicted by the New York Attorney General and Manhattan DA? That is your question, because Rod Rosen is not signing off an indictment for Trump. Not going to happen. Not going to happen. Not going to happen. But could New York indict him? That's your question.
Recognition power?
Recognition now?
About the president's ability to
Well,
recognize.
I don't share everything that Josh said. I think the president can violate the obstruction of justice statute. Depends on what he's doing. I mean, he could be bribing some witness before a grand jury. I think that would be obstruction of justice.
I agree.
So I think you want to calibrate that a little more carefully. There is a problem, however, with what's going on in the discussions of Trump and obstruction of justice. We did a piece, David Guzman and I, in Just Security. I mean, there is a tough case from Mueller if he wants to bring an obstruction case on the firing of Comey. I'm not saying it's a complete loser, but it runs in the face of two Supreme Court decisions that have put barriers into obstruction of justice statutes because they are so malleable, so easily to manipulate. So we have to be careful of, and I think it's in part a function of having a special counsel as opposed to an ordinary regional U.S. attorney, potentially criminalizing everything that the president is doing. It has got to be an enormous distraction, even if we had a president with the character and stability and verbal fluidity of an Obama. If he was under this kind of constant pressure, believe me, it would get to him, and he would have conversations with subordinates saying something like, why didn't I have a Bob Kennedy as my Attorney General? It's just, we have entered into a new sphere here. The Kennedys had a lot of holdings. They weren't challenged for those holdings. They were so-called blind trust. I think the son-in-law or the brother-in-law raised. I mean, it's a different era. There's a presumption of regularity, which I think does the country good. And to some extent, the Nixonian era, all the legacy of it, we've gotten to a point where we are creating a problem that outweighs the benefits of those measures, I think.
So,
can I just make one comment in response to both of these, because I think we're sort of converging on a point of significant, in part disagreement. I mean, I think that Sandy don't disagree with everything that Josh said. I think I actually probably disagree with most of what Josh said. But again, I want to put this in an institutional context. This reference to the energetic executive instills in me a high level of anxiety. Because I agree with it fundamentally until our concept of the energetic executive starts to tilt into Seizureism.
Yes.
And the moment you have Seizureism, or what some people have said more modestly, aggressive presidentialism, then it does seem to me that we have to think about the constraints on the president, and particularly the constitutional constraints on the president, in a different way. The last example I give, I don't want to go too long about this, is the pardon power. I don't know what the basis is, I just don't agree that the pardon power is quote unquote absolute. You said pretty damn near absolute.
I did say that, didn't I?
You said pretty damn near absolute. So you opened the door a little bit for us to reach an agreement on it.
Yes.
But it certainly is absolute with respect, I can't think of a case where it wouldn't be absolute with respect to the beneficiary. I can imagine where the beneficiary of the pardon walks away with that pardon and can count on it. I do not see any way that the corrupt issuance of a pardon, whether it's for money, or we can discuss the other circumstances in which that corruption was apparent. I cannot see any reason in the world why we would want in the modern presidency to establish the principle that a president has a tool like the pardon power that he can use regardless of the evidence of corrupt purpose. Now someone will say, well, now we're going to go down the road of extensive investigations and inquiries into motive, and now we're back to an issue of execution and good judgment. And the entire ability to manage these documents appropriately rests fundamentally on good faith and good judgment. And in a polarized politics, I concede to you, particularly the polarized judiciary, that that's a challenge. But I don't think the answer to that is to say, oh yes, but otherwise we'll be undercutting the capacity of presidents to behave energetically.
So looking prospectively, where do you think there's going to be any, do you think this represents kind of new institutional development in the presidency? Do you think that you're going to start seeing Congress assert itself in something like an Independent Counsel Act? Or do you think that, what Professor McConnell said, the fact that, half of the Congress won't do anything, half the Congress will do something is a pretty good indication that this is that there's going to be no new institutional changes to how things exist.
Well, briefly, I do not support the restoration of the Independent Counsel statute. I think
We agree on something.
Yeah, I believe it was a mistake at the time. I strongly oppose the involvement of the judiciary in the supervision of the Independent Counsel. I do not support the bills that would have the judiciary supervise or rather judge the good cause of a presidential dismissal. I do think there ought to be special counsel regulations. The conflicts of interest have to be managed in some way within the executive branch. I don't know where this is heading. I would not count on, I'm going to put this sort of diplomatically, I would not put a lot of money on an entirely constructive legislative response.
I think there's a lot of agreement on the panel here. I think we're talking about administration of a motive of inquiry, and it's got to be very, very limited, is my proposal. And And I think all people of good faith and conscience should be resisting what we're seeing, no matter how the political axe falls.
And let me elaborate on the sort of mixed motives approach, which Sam mentioned earlier. He's a maven of administrative law, a maven of employment law, and also national security law. Your Attorney General of New York.
Just say I'm a maven.
He's a maven. He's amazing. Your Attorney General Eric Schneider filed a lawsuit against President Trump, among many, and he urged that the rescission of the DACA program, the Deferred Action Program, was unlawful. And one of the reasons why he urged this is because President Trump has made statements exhibiting animus towards Mexicans and Latinos. For example, he threw Jorge Ramos out of an interview, and he said that Mexicans are murderers and rapists, and you can go down the litany of statements, right? He said, as a result of this animus, the president can't wind down DACA. Now, I want you to take that position seriously for a minute, right? If every action President Trump takes is tainted by that, how do you cure that taint? And if you can't cure that taint, President Trump is now disabled from being president to a huge portion of this hemisphere, right, of foreign policy actions. Now, it's not just Hispanics and Latinos. Trump has pissed off virtually everyone in the world at some point. Jews, whites, black, it doesn't matter. He's pissed everyone off, right? If we take this motives regime to its logical conclusion, we now have a president in name only. Because courts can nationwide injunction, nationwide, bam, 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 stop him, right? Maybe it's Trump's fault, right? Maybe some of this character should not have been elected, but he was elected. And this is why it troubles me so when courts look at motive to try and disable him. So rather than having a Caesar, we have basically a Caesar salad, right? Just sits there and does nothing, because courts can stop him at every whim. Which is why I think the Supreme Court has wisely intervened, and I think they will calm and use Jack Goldsmith's language, lower the temperature a bit. I'm glad we are here today in 2018 and not where we were last year.
Let's talk about the steel seizure salad.
Absolutely, I like
that.
that. With croutons.
Yeah, it's pretty good. So I had a question about who's going to decide. So everyone has their theory about what the president is allowed, whether a motive inquiry is appropriate, whether or not obstruction is an impeachable offense. But you note in your article on lawfare that at the end of the day, it's going to be the Senate that's making the decision here, and they're the ones who are going to have to decide whether or not they find the precedent, whether or not they're swayed by the precedent. Who's going to be making these decisions as a practical matter?
Was that from your Bob?
Either.
Oh, I thought you referred to this.
Oh,
yes.
He has lawfare also. Okay, so is your question how is the Senate going to be making these determinations? Is that what your question is?
So is it the Senate that's going to be making these determinations? And if so, how do you think that'll play out?
So let me start off by saying I do not think the impeachment trial is a purely political process. You know, if someone says, impeachment, whatever the Senate can muster votes for, I do not accept that. I think senators take an oath to the Constitution, and they should take that oath seriously and responsibly. With that being said, I don't think anyone will care, right? I probably will be testifying at that trial next, which is why I'm dreading the Democrats saying, it'll ruin my life to have to testify at this hearing. But assuming there's a hearing, right, they're not going to listen to a word I'm saying because they hate Trump. This polarization is half the Senate will like it, half the Senate will hate it, and I don't think we'll go anywhere. But one point to make clear, the Senate sitting as an impeachment court is not an Article 3 court. And the usual rules of evidence don't apply. And indeed, I think they can consider presidential motivations in ways. I mean, I've been reading a lot on the Johnson impeachment trial, which when, again, if you haven't studied this, President Johnson, among other things, removed the Secretary of War, a guy named Stanton, who was a holdover. And the Senate said, no, you can't fire him without our advice and consent, the lawful tenure in office act, right? A lot of this was about Johnson's intent. It mentions his corruptly removing it. Let's use those words, but you know, basically the idea of a corrupt intent, that he was disregarding the law. This is why I am hesitant to go down the intent road, because once you start making malleable the standard of intent, you can find anything to be criminal or impeachable, which is why I think the Article 2 argument of did Trump have this power, was it a lawful exercise, and that's the end of the inquiry. I think that's a much more productive question.
I think it is it's a political process, and different senators will have different senses of their own responsibility to make this decision independent of the political consequences. I think that has been the history of this process. I don't think it would make a lot of sense for a court to be deciding whether misuse of the pardon power is an impeachable offense. at the end of the day, there'll be a collective judgment that the president has abused his authority. We no longer have confidence in him. There would be that kind of global judgment, and law would play a role, and other things are going to play a role. You know, it is the Johnson impeachment, according to Wilson, and like legislative history, I'm using Wilson when it works to my advantage. But the Johnson impeachment, according to Wilson, led to decades of congressional government. It led to an enfeebled executive. So I think many senators will be understanding of the consequences of letting their politics run the impeachment. I'm not sure even that the House, I mean, Pardeen said that if the Democrats win the House, there's an impeachment. There's certainly going to be pressure for an impeachment from the House. I think there are conscientious members of the House as well that would resist it. But we'll see. We'll see.
The impeachment motion be brought to the floor without the Speaker's consent. It was a non-privileged, I'm getting the terminology wrong,
Right.
but any member can bring it to the floor, and any Democrat who votes against that is probably going to be voted in primary. So I think we're going to have an impeachment.
Want to take questions?
Yeah, so start queuing up for questions from the audience, and I'll have one more to ask after. Did you want to comment on the? Did you want to comment on?
No, I agree with you. I think at the end of, for example, the case of the Clinton impeachment, every single, the public's assessment of whether the administration is viable anymore has an enormous effect on the outcome of the impeachment inquiry. That certainly was true for Clinton's case. He had very high poll ratings. Republicans could not wait to get out of it, and they knew that they could all vote, with the exception of our own inspector, uniformly to convict Clinton, but they weren't actually going to be able to oust him from office, and they were absolutely thrilled because they didn't want to get into that. They wanted to cast the easy vote. I think in Nixon's case, there were a variety of reasons why at the very, very end, his political position collapsed. But in part it was because even Republican voters who had stood behind him for this entire period of time came to the conclusion that he was no longer able to run the country. That his administration was collapsing, and nothing in the United States damages a politician more than the perception of irrelevance or ineffectiveness, and that was not what Nixon had brought into office. So I think it's complex what moves the Congress to ultimately make the decision to impeach or not to impeach.
So I have one final question for Professor Blackman, and that's so the claim that while in the enacting in his Article 2 capacity, the president can't commit obstruction of justice. Might you just talk about previous impeachments and whether or not you think for instance, the Nixon and the Clinton impeachment, where they fall in your theory?
Let's talk about bribery. So, see, he's a good lawyer, right? Everybody said pretty damn near absolute, and I said that pretty carefully. Impeachment specifies 2 grounds, or 3 grounds: bribery, treason, or high crimes and misdemeanors. Taking a bribe for pardon is bribery, so that's a carve out, right? Richard Nixon, there's basically allegations of trying to bribe. There are allegations trying to tell people to lie on their oath. That is not within his Article 2 powers. I can't see any relevant claim of why that's within his Article 2 powers. The Clinton impeachment, that he purged himself under oath with Paula Jones and all that stuff. Again, that's not within the president's capacity. It was all of this various ancillary stuff that had nothing to do with the office. Johnson, that was a core exercise of his Article 2 powers, firing the Secretary of War. Now, we can debate about what the Senate actually did, but they didn't convict. He was acquitted by a single vote. And in my mind, that's an acquittal, right? He was acquitted. And I view that as a judgment of the Constitution. Now, people don't agree with that, but that's my reading. So I think the Clinton one, he had no valid Article 2 argument. With Nixon, there was no Article 2. Johnson had it. I do think Trump would have an Article 2 argument as well. Like maybe do that during Q&A.
So we'll open it up for Q&A. Do you want to take it?
I think that among the issues that we're discussing here, this practice of nationwide injunctions is a very serious one, because that's when I can see that we've broken the dam, and this could flow into future administrations. This could become a whole new practice, a widespread practice that would continue past this administration. So I'd be interested in the panel's views on the possibility of an anti-injunction statute, not to prohibit nationwide injunctions, but it would have 3 parts. If there was a nationwide injunction, the federal government would have immediate right of appeal to circuit court. The injunction would be stayed during the appeal, and the circuit court would make a de novo, the two-judge panel would make a de novo review of the nationwide injunction, because I think this is a much more serious thing than most other TROs that a district court would grant. So that's a thought of the solution. I'd be interested in your views.
Well, I think a lot of the points you make, they're good ones. There should be support for it. But again, I think maybe a complementary solution would be to have a geographic limit on the scope of the injunction. This may be something that the circuit courts could adopt as a rule, and they should be encouraged to do so. I think the immediate appeal is there now. The stay is not. But the immediate appeal is there now.
The de novo one is good because with the stay, it's seeking irreparable harm, right? And often maintaining the ex ante status quo is desirable with that sort of balance work. But the most important thing to say was de novo, because that changes the burden as well. We just leave the status quo, keep the travel ban on hold, let these people keep coming as they were before. I do like the idea of reining in a nationwide injunction. And let me just give you a twist. I was okay with Texas's nationwide injunction in the DAPA litigation. One of the reasons why was that you had a single court with 26 states, and there wasn't this dual nationwide injunction. Everyone funneled into a single court. What we're seeing now is California files here, New York files there, Maryland files there, and you have 3 different bites at the apple. The government has to bat 1,000, the resistance has to hit only 1. And what we actually have is one judge in Maryland said the DACA rescission was valid, but other judges in San Francisco and Brooklyn said, no, it's not. The Maryland judge has just been obviated. He's irrelevant. So funneling it into a single 3-judge panel with an immediate appeal to the Supreme Court, actually Adam White, who's in the back, proposed this as well. I think we need more 3-judge panels with straight appeal to the Supreme Court. I think that would actually be a salutary improvement to our
That's Greg Costa's approach
Yeah.
as well. You know, the no-go standard may be hard to apply here because of some aspects of the district court's decision are sort of fact-based. It may be hard to apply, but the spirit of what you're recommending, I agree with.
Yes, my question is actually also related. Also, why your view of Congress exercising its Article 3, Section 2, Clause 2 authority on nationwide injunctions, but also in a lot of these cases just to strip jurisdictions from the district tyrants to decide cases on specific subject, remove subject jurisdiction on DACA, remove subject jurisdiction on all of these other matters, and I think that would be a pretty quick solution and what your view is. And I'd just like to make one quick factual correction to some of the baseless ad hominem attacks on our president. He never stated what you implied either about Mexicans or Hispanics or blacks or Jews. So just one of the many baseless ad hominem attacks I want to address. Thank you.
Can I speak to the injunction issue, and maybe Bob wants to refer to the other? And here's where my
I think that was addressed to Josh. I didn't.
I'm sorry,
I didn't
address
refer
this?
to
No, no.
Well,
I'm sorry.
Yeah, I'll take the ad hominems part.
Which
I think what I said was that-
let me finish my point first.
Okay.
Don't mind. I was in the middle of the sentence. I think, and this is where my liberal democratic thing comes out. I think there's a problem with sort of selectively. I think Congress has the power, generally speaking. I agree with you there, but I think there's a problem with taking some subject matter out of the province of the general jurisdiction of the federal courts. And again, it's a question of whose ox gets gored. We need a rule. We're going to be thinking about rules, not in terms of how they're going to play in this administration, but how they're going to play across the board over time. And I think there's some experience. People who don't like abortions have tried to curtail the jurisdiction. People don't like civil rights prosecution. I think it's better to have, it's politically more viable and better on the merits to have a more general regulation of the nationwide injunction. More people will agree with it. It will appear to be principled, and in fact will be principled. Josh?
Yeah, I'll address that. So I think a lot of Trump's statements in overflow are actually chronicled these at some length. He did call for the muzzle ban, and he backed off it. He said he got different advice. After the election, I don't think any of his statements come close to showing it. His detractors have to cite obscurities from Rudy Giuliani to try and get it, but I don't think Rudy said what people said he said. The point I made, though, was not that he actually had the intent to offend these groups, but he's offended massive groups over and over again. Some of these things I think are probably overblown. But the courts have looked at Trump's tweets and inferred from this animus. And that's what I was referring to, not that he had perhaps the intent to do this, but his words had the effect. And when the courts applied what's called the objective, was it the reasonable observer standard, or for the Imperial County case, the reasonable observer standard, it doesn't matter whatever Trump's intent was. It's how people understand his comments. So if we start from the presumption that whoever Trump has offended now has standing to raise an animus claim, he then becomes disabled to be the president. The first part about jurisdiction stripping, this is old as federal courts, go back to McCardle and other cases. I don't know. I think the proposal is to perhaps, like Judge Costa says, to funnel litigation for nationwide injunctions to a single court. Perhaps what Sam says, limit the geographic restraints of a state. I think that'd be salutary. But to have now judges issuing global TROs with a couple hours of briefing, global TROs with a couple hours of briefing, I think is really, really problematic. And the travel ban litigation, I think, should be studied for years to see how perhaps that could have gone wrong. Also, wasn't helping the fact there was no AG confirmed. Sally H is still at the helm. And that was a very problematic aspect of the entire exercise. She exactly what she did or didn't do, I'm still trying to find out for you. But there's some issues lingering there. But thank you for the question.
Yeah, I just wanted to note one other thing that I don't want to go into right now because I don't want to take away time for the questioning, but Josh also said something to the effect of, the real question is whether the president's operating within his core constitutional authority. And to me, there's something peculiar about the notion that the president, as long as the president's operating within a core authority, then the question of abuse essentially isn't presented, because that can't possibly be right. You could imagine a president, for example, who's operating within his core constitutional authority, authorizing military action in a sort of wag the dog fashion for the purpose of distracting public opinion from personal difficulties or, seeking to achieve some other motive totally unrelated to the interests of national security. I think that would be entirely impeachable if, in fact, facts to that effect became public.
Just to amplify that point, there's a difference between what's impeachable and what should be the subject of a federal criminal prosecution or a state criminal prosecution.
That is correct, and one of the most interesting things about the Johnson case is why you mentioned that there was an inquiry into intent. I don't think there was really an inquiry into intent at all. He violated the statute because his administration concluded that the constraints put upon him were unconstitutional.
The underlying concern why he was impeached was his misuse of the pardon power.
Precisely.
In that case.
Yeah, and other ways in which the Congress thought that he was completely using the authority of his office and undermining congressional authority to maintain Lincoln's Reconstruction policy. Yeah. They flinched from asserting the broader constitutional claim against him and decided they needed a specific legal violation and set us on the path that we are on today.
Exactly. David?
Thank you very much for the panelists. I've got a question. So when there are indicia of bad intent, could the panel talk a little bit about what sort of curative actions you can imagine such that we return to the status quo of deference? Thank you.
Yeah, so let's talk about the presumption of regularity. Sam alluded to it earlier. This is an important part which I've written about at some length. There's presumption that when the president acts, he presumably acts lawfully. And that presumption, like all presumptions, can be rebutted. I think most courts have tried to rebut that. But when can the president cure it? Right? I was at the arguments in the Fourth Circuit on the travel ban a few months ago in Richmond, and one of the judges asked the lawyer from the ACLU, what if the president apologized, right? Said, what, I'm really sorry. I didn't mean to call for a suspension of entry of Muslims to the United States. Would that change your position? And the lawyer, I think, wisely said, no, it would not. There is no curing it, right? I think the position is once you have this evil intent in whatever record you have, that's it, and the president's permanently disabled. That might work in McDonnell Douglas framework burden shifting, right? That might work in a mundane, routine case like domestic law. That cannot be the rule for the commander-in-chief, who very well may need to take us into war. with a country that he perhaps expressed these comments towards. That really worries me. And let me just use this as an example. Let's say, we get into war with, I don't know, Syria, Libya, whatever country you want, and the president says, you know what, I'm going to suspend entry from Syrian nationals or Libyan nationals, whatever country. Aside from the travel ban, which was suspended all, we can't have people coming in. And the court says, no, you can't do that, animus. I mean, this is no different than when Justice Douglas issued an order to stop the bombings in Cambodia, right? This is a dangerous jurisprudence we have in front of us. And let's talk about it now, but when it hits, and a judge issues a TRR saying, you can't do this, they're going to grab Justice Douglas in the mountains, wherever he was. No, the Supreme Court's going to intervene, and for reasons that I think are wise.
So I have a question for Professor Estreicher on the removal jurisprudence, the ability of the president to remove officers. Professor Blackman and Bauer have kind of gone back and forth about what's the scope of the president's power. There's a sort of two dueling line of cases. Where do you come down on with respect to specifically in this obstruction issue, whether or not the president is exercising his Title II authority when he removes one of these officers?
You're referring to the special counsel?
So
Or Comey.
take Comey, yeah, so Comey to
I
begin
may
with.
not have a purist view. I believe the president has a take care responsibility, which means that he's subject to statutes and also agency regulations. There's a special regulation that was promulgated by the Justice Department, which provides for the supervision by Rosenstein. He'd have to remove Rosenstein. Can he remove Rosenstein? Yes. There's no statutory restriction on his ability to remove Rosenstein. I'm against the various measures that are being floated out there to provide a statutory basis for the special counsel, because we're just going to come back to the independent counsel problems that we encountered. So I think the president can remove. Now, if you're asking me a broader question, can the president remove the members of an independent agency where Congress has provided? Right, is that what you're asking?
Yeah, I mean, I'm assuming the answer is no.
That's where, well, the people that argue that there's a unitary executive, I don't know if they still are arguing that, because I think...
We are.
You are. I don't think Elena Kagan will be arguing to the energetic president for a while. Again, I believe in general the president's authority is subject to law, whether we like that law or not, unless it interferes with a core exclusive responsibility of the president. And I don't think controlling the independent agencies implicates that. Now, we don't know for a fact, at least the Humphreys executive case involved, as the name of the case reveals, a claim for money on the part of the widow. We've not actually seen the application of this kind of thing. It certainly was very troubling that Stanton could not be kicked out of his office by Johnson when Johnson wanted to communicate with his commanders in the field. So I think when it encumbers the commander-in-chief function, I think we have to look very closely at it.
So I'd ask Professor Bauer, you in one of the articles in Lawfare don't put as much stock in the Myers case because of intervening jurisprudence. What do you think is the ability of the president to remove these officers?
I think the president obviously has a wide berth in the administration of the office to dismiss officers. However, I also believe that it matters that touch upon the president's own personal interests. And again, I understand there are issues of execution, concerns about runaway, Javert-like prosecutions. All of these are significant issues, right? And we certainly have heard Democrats complaining loudly enough, and I think the justification, say about independent counsel Ken Starr's Javert-like pursuit of Bill Clinton, right? But having said that, I think that if there is going to be any teeth at all in the maxim that the president is not above the law, it has to be in circumstances in which the president is utilizing the powers of the office to protect himself from appropriate inquiry into the legality of his conduct. Let me also say, I have puzzled for a long time over the 1973, 2000, and 2000 Office of Legal Counsel opinions, finding that the president cannot be indicted in office. I note only for the record that both opinions were generated in administrations whose presidents were impeached. And these were executive branch decisions, and I don't think they really are entitled to much weight. plus the reasoning is wholly unpersuasive. There's absolutely no clear constitutional authority for the principle that a president cannot be indicted. Now, if the question is, do we want to set into motion a train of events by which each political party is anxious to criminalize the conduct of the president and to seek indictment and therefore removal through the legal rather than the electoral process? The answer is no. But there is no way to work around these issues of institutional integrity and individual good faith. At the end of the day, you cannot create a doctrine that cannot be abused. But the worst thing that you can do is to create a doctrine that shields this powerful figure.
It will never be an absolute shield. By the way, the practical issues should inform the content of the principle. You think it's going to be manipulated. And by the way, indictment of the president, any U.S. attorney, state prosecutors,
well, U.S. attorneys are not
for official conduct. I know that my former colleague Walter Dellinger had a piece in the Times based on Jones, but I think he misread Jones with all deference. Jones is about unofficial conduct.
And if I could interject,
let me finish one point. Just because we can recognize in principle that if you use a power for a personal motive that is an abuse, make that a subject of your impeachment inquiry. It should not be a criminal act.
And let me make this briefly. The practical issue is not if a federal prosecutor does it, it's a state prosecutor. Someone within Trump's administration is not going to indict him unless they have a defendant counsel statute. Ken Starr could have indicted Clinton, Javert, right? Bob Mueller cannot.
Let me just ask a question of Sam and Josh, just to be clear. So if the president got a president, this is not on the table with this president. Right. So we're going to move away from Trump, which is always, sanity restorative. Let's assume a president.
Go beyond Trump.
Yes. Let's assume that a president sells pardons. Clearly impeachable. I think everybody in the panel will agree that's an impeachable offense or not.
I'm not going to commit.
Okay.
I agree.
Does it fall under your pretty damn good clause?
I'm going to abjure for the moment. I didn't say
okay, well, at least I got you doing during
You have my vote, Bob.
Thank you. Now, can he be prosecuted for selling pardons?
Selling, I think that could be bribery, yes.
After he's impeached, he can be prosecuted.
But not, I'm not talking about impeachment. I'm talking about criminal prosecution.
I think
the exercise of a core authority.
I think after the presidency, I think he probably could, yeah.
But only afterwards.
After he's been impeached.
Yeah.
Convicted, I should say.
I think he'd have, or if he just served out his term and he finished.
What about during?
No.
I don't think how can you hold the president to a criminal trial while he's in office? Or imagine it. This was actually my final exam question last year, right? Where a New York State judge had a criminal trial for the president, and afterwards he remanded the president to custody, right? Just think about that for a second. Punishment is jail. Go. The Secret Service saying, not over our dead bodies. And the marshal saying, yeah, let's do it. Can't have it. And an indictment, I'm on the fence about. I think Bob's right. The opinions aren't clear cut, so I'm going to abjure that one also. But I think for sure you can't try the president during his term.
Why are you abjuring rather than agreeing with me?
I haven't made up my mind yet. I try to have an open mind with these things. And I read the Olsey opinion from 70 whatever in 2000, and I'm not there yet. I believe it or not, I do think before I say something, I try. Believe it or not.
Very commendable.
That's all right.
You have a question?
Yeah, my question is so mundane after the selling pardons hypothetical, but on the nationwide injunctions, I tend to be a little worried about them, although I hope Bob will forgive me. I tended to like them more in the previous administration.
I'm sorry.
Nationwide injunctions. But suddenly I recognize, oh gosh, there might be a problem here.
Exactly my point.
But what gives me pause is the APA, at least in actions arising, agency actions that are being challenged in court. The APA says, in 5 U.S.C. 706, the remedy is the court shall hold unlawful and set aside the agency action. It seems right there a reasonable basis for nationwide action.
Well, that does not preclude the administration from taking a different position in other circuits.
Yes.
That's my point. It does not. Well, it has that effect in that circuit, and the government can relitigate without being subject to the contempt power of that court.
There's also the remand without vacatur, which is the D.C. Circuit's beloved standard, where they can find a ruling unlawful, remand to the agency, but leave it in place. And it's actually a judge in D.C., I think it's Judge Bates, who is considering striking out the DACA rescission under the APA 706. I'm going to write at some point, I think it should be a remand with a vacater. But the APA allows a nationwide injunction. The rules of procedure do not.
The APA does not speak to that issue. I know my APA, it does not speak to that issue. I understand.
Professor McConnell.
So, since there was no one else up, I wanted just to ask about whether the panelists are worried about the criminalization of politics in general, and I think, so maybe the president isn't going to be indicted while he's in office, or the Secretary of State while they're in office, or the Attorney General while they're in office, but as soon as the parties shift, are we going to see a spate of vindictive political prosecutions? And I think that we are really sliding into dangerous waters here. You know, Hillary Clinton looked like she violated the law, but I personally was quite relieved that she was not criminally prosecuted for that. We talk about selling of pardons. It happened. Bill Clinton's pardon of Mark Rich is at least something you could go to the jury on, but it's a good, I think it's good for the country that we didn't, his successors didn't prosecute him. Attorney General Holder committed contempt of Congress, and the matter was before the district court as the administrations changed, and within about a month, the Trump administration dropped the matter, and they probably would have prevailed. I don't see why not, but it was a good thing that they dropped the matter. I think the idea that the two parties are bringing criminal prosecutions against each other whenever they're in power is a really dangerous proposition.
Agreed.
I agree with you.
I agree, but I'm not sure. I do agree with you. I'm totally about the criminalization of politics, but I read the term differently than you do. To me, the criminalization of politics, it has been an issue, is when the government begins to regulate in some detail various aspects of the conduct of political activity. Think about, for example, post-Watergate reforms, and that forms the statutory basis for significant regulatory intervention in the political process, which can be enforced both civilly and criminally. And I view that as a very alarming development. And as a lawyer who's been in the political process, and frankly, you know, I'm not proud of every charge I've associated my name with on behalf of a client. I do think that's problematic. But I think it's a mistake, and I also agree with you that sort of polarized, a very polarized trend toward trying to criminalize differences is very disturbing. I don't disagree with that. But I don't know why that would impeach the general concern with criminal conduct in the highest offices of land. And by the way, I'm not saying this because I've reached any conclusion, because I don't have any basis for a conclusion at the moment. We'll find out whether, in fact, Donald Trump has violated the criminal laws of the United States. Every time Bob Mueller issues an indictment, everybody's surprised and said, why didn't that was coming? Maybe he won't move on it, and maybe there's no basis for it. I've never, even in a public setting, expressed anything but some significant doubt about it, but I couldn't say that I could reach a definitive conclusion at this stage. But having said that, I don't know that it's I don't know why the general concern with the criminalization of product ought to insulate a president or a secretary of state who criminally abuses office for personal gain or for political gain. I don't see why that larger concern ought to be so all-encompassing that we ought to turn away from significant evidence of the kind of misconduct. And again, I want to get back to the institutional point that we want to discourage the president from believing he is at liberty to engage in. It's like this whole business about the pardon power is absolute, the pardon power is absolute. Why are we telling presidents, not just this one but subsequent ones, don't worry about it, it's a constitutional free fire zone? I think in light of the development of that office, I think that's a significant mistake.
So I have a question for Professor Blackman about that exam, about your final exam. What did the A paper say?
So I mean, here was the setup, right? The New York, the Manhattan DA had an indictment against Trump for both offenses before office and during his office. And the court found conviction. In the last scene, the judge says, okay, I find that Dr. Ventrell, the defendant is guilty, and remand to custody. And then the Secret Service goes, no, and the marshal says, we're remanding to custody. I think the answer is McCulloch v. Maryland. And if you recall, the facts of that case were, could the state of Maryland impose a tax on a federal institution? Now, this wasn't a generally applicable tax. This was a tax designed to destroy the institution. And I think the reason why I'm somewhat abjuring is I think there might be some separation of powers issues for federal officers being indicted by a state officer. I think there's some supremacy clause issues that are legitimate. So I'm somewhat on the fence. But if a person did engage in criminal acts in the state, there's actually due process issues about whether the state can go after the officials. So these are really difficult questions. The right answer, I think, is that if a state tried to prosecute the president, I think you would have the Old Writs Act, and you'd have to have Supreme Court intervention immediately. You wouldn't even get to it.
Isn't that removable? Is the criminal prosecution removable?
Can you, Michael,
I think
McConnell's shaking his head, but what if it's a purely state offense, like, like a libel?
So what?
Doesn't matter.
So any offense could be moved to federal court?
Against a federal officer.
Right.
Is that Westlaw? No, that's for
No, that's
civil.
a removal statute. There's provision.
Okay, then maybe removal. Okay, maybe that's the answer.
Yes.
Hi, my name is Maureen Spies. Speaking about pardons, I have a vague memory that in the past few months, Trump either said or was alleged to have said, either publicly or sort of thinking out loud in public, could he pardon himself? I wonder if anybody else remembers this and if anyone has any comment on it. Thank you.
I don't remember the statement.
I remember others having asked the question. I don't remember it coming out of his own mouth.
Okay, so can the president?
I think he's made the statement people construed to cover that point by saying it's absolute. I think he said something that suggested that he thought that it was unbounded, and then maybe from that it was extrapolated that he meant that he can pardon himself, but I don't recall that specific statement.
Nor do I.
So I'll ask the question, can the president pardon himself?
I'm sure.
I haven't looked at it closely, but it would be an impeachable offense.
Let me give you a textual argument that give you an answer. The idea of giving a pardon suggests two people. There's the giver and the receiver, right? I think property law as well, right? You give a gift, there's a donor and a donee. Remember back to one-owned property. Can the same person be the donor and the donee? Probably not. So I mean, textually, there's a reason why it wouldn't work, but I'm abjuring beyond that.
Professor Brown?
Yeah. I don't know that I buy into the textual argument. I mean, the most recent pardon was one conferred by a vice president on the president. That's two people, sort of. You can't vote for them separately anymore, so they're really sort of conjoined political twins. And that's really true, but in any event. But in my view, it's certainly, I agree with Sam, it's certainly potentially an impeachable offense. And I could imagine circumstances, and it would have to be based on a factual record that we're not discussing here, where it could be worse. I mean, not worse than that, because for most politicians, being impeached is worse than being put in jail. But it would be potentially expose the president to criminal liability. But I'm less clear about the circumstances in which that would be the case.
And just one final question, a little kind of fancy. Can the vice president, if the president invokes the 25th Amendment, does the vice president have the pardon power?
Has he been elevated yet?
Yeah. Temporarily.
Oh, that's a good question.
Yeah, that's a really good question. But my intuitive first thought would be that he would.
Yeah.
So then the president could elevate the vice president, get the pardon, and then.
I think you can final exam questions ideas.
Yeah.
Yes, I suspect so, and then that'll be an interesting
So
question.
then you can pardon, so effectively you can pardon.
And then
yourself.
they can go back, so right, the president pardons the vice
Yeah,
president.
yeah.
Right.
Yeah.
And you get a pardon, you get a pardon, you get a pardon. Right?
Another question.
Yeah, the question is related. Can he pardon a co-conspirator?
Yes.
He could, absolutely, and I think the interesting question is there ever, I don't see a basis, and there are people who looked at this more deeply than I have, and so I'd be interested with my panelists, Professor McConnell or others, and I don't see a circumstance in which the pardon is an absolute with respect to the pardonee. I just think the president himself is exposed.
So you think the pardon remains valid, we can prosecute for?
That's what, when someone says the pardon power is absolute, I don't disagree with that. I think that if the president pardons the co-conspirator wrongly for a corrupt motive, that's a good deal for the co-conspirator. I don't think that the pardon can be questioned, can't be revoked. But I think that the president is at legal risk for having issues.
Can he be prosecuted criminally for it while in office?
What, for
For any use of the pardon power?
Well, as you know, in my view, yes, but that isn't because I'm in a sort of a cavalier mode of saying, let's prosecute him for this, that, and the other thing, so that, you know, the White House counsel winds up being a criminal law boutique. I'm not in favor of that, but I do think that, yes, again, depending on the factual record, I don't think there's a broad constitutional exemption that applies for immunity.
Gotcha.
I just want to pile on Max's hypo for a second. Does the pardon in either of those scenarios insulate the president from impeachment? I would presume not, but then in that case, and considering that some people do continue to shoot off their mouths about it, what would be the point? I mean, it seems more likely that something that the president would feel a need to pardon himself or a close associate from would be of the level to get him impeached. Otherwise, it's more.
It could be a prospective criminal pardon, going forward, saying that he can't be prosecuted after he leaves office, right? Well, I think a former official could actually be impeached because you can disqualify from holding perhaps future appointed office. But you could actually have a prospective impeachment. Any indictments that might arise for past offenses. Didn't George Bush one of those two? Was with the Noriega stuff? Who was that? HW. Yeah, HW. Who did he pardon like that? Yeah, that's Casper. Yeah, that's it. Thank you.
But I think the fear is that the president would use it to undermine the Mueller investigation. I mean, that was the fear, that people would not cooperate with it.
Moot it, right? I mean, undermine it, but moot it.
Yeah, he pardoned everyone.
He pardons everybody, and he has a big
He'd have to pardon everyone, yes.
And then Mueller doesn't have anything to do anymore.
Oh, you'll find something.
Gotcha.
The Russian student.
Where's lunch, by the way?
Is there any more questions?
Lunch in this room?
Lunch is in this room. I mean, it looks like it.
Yes. That's very important information.
Lunch is in this room, so everyone enjoy. I don't want
Thank
to.
you, folks.
Thank you very much.